Hello students, I hope you all are doing great. Today we at ClatPrep would be decoding the important news article, very important story about the Criminal Procedure Identification Bill 2022. Guys, yesterday in Lok Sabha, the Minister of Home Affairs, the Minister of State in the Ministry of Home Affairs has tabled this bill in Lok Sabha. So we'll be understanding this important news article, very important for all the law students, for those students preparing for UPSC and all the government examinations, right? So the Criminal Procedure Identification Bill 2022 and how it conflicts with Article 20 Clause 3, right? So let us begin with the session. Guys, on the very front page of the Hindu today, you had this article about the protests in Lok Sabha, which is envisaging with regard to this bill, right? So let us try to understand this bill and the controversies involved. Guys, as the name suggests, Criminal Procedure Identification Bill. In this sense, this bill would be identifying the criminals. We must understand, students, that with the advancement of technology, there has been increasing trends of different methods used by criminals, right, in the commission of offenses, right? So there have been increasing trend of different methods, scientific methods used by criminals, in committing the offense, right? So therefore the government decided, to increase the scope of the measurements, right? The samples that the police collects, for identification of the criminal, right? So in most of the advanced countries in the world, we see that the new scientific and modern methods are being used to collect the samples for criminals, right? So India also is rightly posed to expand its scope of measurements, right, by including various things which would identify a criminal, right? So guys, the Criminal Procedure Identification Bill 2022 seeks to expand the measurement to identify the criminals. Now it would be amending the Identification of Prisoners Act of 1920. So it is a draconian or a British colonial law in 1920, the Identification of Prisoners Act. It included various measurements like finger impression and footprint impressions, right? So there are only two measurements which were being recorded while identifying the criminal: the finger impression and the foot impression, right? And nothing else, correct? And it included them of limited category of convicted and non-convicted persons, right? And even the photographs on the order of a magistrate, right? So only finger impressions and footprint impressions were collected of the accused, right? Plus, if the magistrate ordered, the photographs were also being recorded, right? So in this sense, there was a very narrow scope of the measurement, right? So this bill envisages to increase this scope, and in this way it would be including many other things to identify the criminal. And these include the handwriting, the iris and retina scan, very, very important, the iris and retina scan. Similarly, very controversial biological samples. When I say biological samples, I mean DNA profiling, etc. DNA profiling, DNA samples, right? The physical samples, DNA or biological samples, iris or retina scans. Similarly, the handwritings, the palm print, right? So apart from the finger impressions and the foot impressions, it would expand the scope of the measurements to include the iris and retina records, the biological samples like DNA samples, physical samples, and their analysis, right? In this sense, the government is thinking to expand the scope of the criminal procedure or identification of the criminal, right? because of the increasing trend of crime on the modern methods which are being used by the criminal in the commission of offense, right? Guys, very important, and I expect a question on this. It would empower the NCRB. NCRB is National Crime Records Bureau, right? It would act as a repository to collect, store and preserve the record of measurements. So all the measurements like iris, retina scan and all the things that we have discussed would be preserved, would be stored, would be disseminated, would be shared by NCRB, right? NCRB is National Crime Records Bureau. At the same time, it would also be destroying, it would also have the power to destroy these samples, you know, when it is required, correct? And it can be preserved for at least 75 years, right? So this is a timeline which is being decided by the government in the bill. That means the NCRB would be storing these details up to 75 years. I hope it is clear. Guys, it would also empower the magistrate in the court to direct any person to give measurements, and also, right, so in this sense it would empower the magistrate to direct any person to give the measurements, right? So even the magistrate can ask for these samples. Plus it would also empower the police and the prison officer to take the measurements of any person who resists or refuses to give measurements. That means if in case you are resisting or refusing to give the measurements or the or measure, by when I say measurement, I mean the samples like the iris and the retina scan or the, you know, the biological samples. If you refuse to give those samples, then the police or the prison officer may take them forcibly, right? So this is a very sensitive part of the bill. That means there is a use of force or coercion, and in this way many opposition leaders are saying that it violates Article 20 Clause 3, which talks about self-incrimination. We'll understand this in the coming slides. Guys, resistance to or refusal to allow taking of measurements would be an offense under section 186 of IPC. That means if you refuse to give the samples, if you refuse to allow the taking of measurements, then it would be deemed to be an offense under section 186 of Indian Penal Code. I hope you are getting my point. Very, very important, guys. The bill also seeks to include the persons held under preventive detention law, right? Guys, we all know that if the government fears that any person can be a potential criminal, you know, or can be detrimental to the peace and order in the society, you know, so the government would order the police authorities to detain the person, you know, so that it would help you know, in the prevention of any future crime, right? So that is called as preventive detention law. So you might have seen that when some election rallies are there, many people are being detained under the preventive detention law, so that no future, you know, crime, you know, takes place. It is very you know, debatable, but very importantly, the bill would apply. I mean, all these provisions of the collection of the samples would also apply to the persons who are held under preventive detention law, right? And in this sense, the opposition leaders are saying that it can be misused against political adversaries, right? That means if, let's say, you are protesting against the government, right, and you know that we have every right to protest against the government, right? We have to be critical about the government, but then if you do so, you may be detained under the preventive detention law and your samples may be collected. In this way, it can be, there is a scope of it being misused and mishandled. I hope it is clear. If a person with no criminal background is released without trial, that means if a person who doesn't have any criminal background and is being released without trial or acquitted by the court all records of measurements so taken shall be destroyed. That means if you don't have any criminal background, and if you are being released without trial or acquitted, means released by the court, then all the records of the measurements. So this is a good provision of the bill, that if in case you are being released without trial or you are being acquitted by the court, then all the records of the samples that the court has collected or the police department has collected would be destroyed, right? So in this sense, there is no preservation of the measurements, right? I hope it is clear. So they may ask you that this statement, that how it empowers the magistrate to direct an imprisonment. Similarly, the refusal to allow the taking of measurement is also an offense under IPC section 186. It also would apply to the collection of the measurements to the person held under the preventive detention law, right? So we have understood 3 important statements, and I expect a question on this, right? I hope it is clear. Moving ahead, guys, the bill is actually ambiguous, and when it says that it authorizes for taking measurements of convicts and other persons, right? Now this clause in the bill with regard to other persons is very debatable. The government has not defined what is other person, right? So that means the measurements would be taken of the convicts as well as the other persons for identification and investigation in criminal matters. It doesn't define what the other person mean, right? So it is not defining what is other persons here, and in this way ambit goes beyond convicts, arrested person and the detainees, right? So therefore it is very contentious. Guys, very important, the police personnel up to the rank of head constable have been authorized to record the samples, right? That means the police officials up to the rank of head constables have been authorized, right? So that means the officials above equal to or above the rank of head constable are authorized to record the samples, right? At the same time, it also allows or enables National Crime Record Bureau to share the records with any other law enforcement agency. For example, Enforcement Directorate, CBI, etc. Right? So that means the data with regard to the measurements or the samples of any detained person may also be shared by the NCRB to any other law enforcement agency. This is also a very important statement. Guys, it is not a new thing. The process actually started with the UPA. That means in the UPA regime, they tried integrating the fingerprints and they tried digitizing the fingerprints. They integrated the fingerprints of the person to the national database called as the Crime and Criminal Tracking Network System, CCTNS. You would be remembering a few days back we did had a session on CCTNS, or Crime and Criminal Tracking Network System, right? So that means it is the UPA which started the digitization of the fingerprints when it integrated the fingerprints with the CCTNS, right? So NDA government is saying that we are just expanding the scope, and in this sense we are integrating the scans like the iris scan, the retina scan, the facial recognition to the CCTNS, right? So here also we have learned about CCTNS. We have learned about the power of the NCRB to share the records with the other law enforcement agency. We have discussed about the head constable, the rank of equivalent or above head constable authorized to record the measurements, right? And the meaning or the definition of other person is not yet defined, right? I hope it is clear. Guys, very important. Let us discuss about the benefits or the pros of this bill, right? Guys, the bill is definitely is ensuring the changes in the technology, right? And with the adoption of new technology like the facial recognition, the iris and the retina scanning, the criminal identification system would become more robust, right, would become more efficient, correct? And many advanced countries in the world are using these technologies to identify the criminals, right? So in this way, it would help upgrading the crime solving techniques, correct? So very important, it would upgrade the crime solving techniques for all the students who are writing the UPSC mains. They would also this article would be very helpful for them also. The bill seeks to expand the ambit of persons, right? So it is expanding the ambit of persons whose measurements can be taken, as this will help the investigating agencies to gather sufficient legally admissible evidence. That means all the measurements that we have discussed, like the iris, retina scan, the biological samples, they all now would be regarded as legally admissible evidences. Right. It would also help in unique identification of a person involved in any crime, right? So unique identification of a person involved in any crime, and if he or she repeats such crime, then definitely the police authorities would be better placed to identify the criminal, right, because of the measurements, and will assist the investigating agencies in solving the criminal cases. At the same time, it will also make the investigation of the crime more efficient and fast, and will also help in increasing the conviction rate, right? So in this sense, the conviction rate would also increase. It would make the whole criminal procedure efficient, robust, and expeditious. That means fast, correct? It would also it would also help in unique identification of a person, right, and would upgrade the crime solving technology. I hope it is clear. Guys, there have been a lot of protest in the Lok Sabha, where many opposition leaders have registered their protest. They say that it violates Article 20 Clause 3. Guys, Article 20 is a fundamental right, and it comes under the broad fundamental right of freedom, right to freedom. So Article 20 Clause 3 talks about self-incrimination, and it says that no person can be obliged to be witness against himself, right? That means it clearly says that no person can be obliged to be a witness against himself, right? That means such position should not be made, should not be created, which would force the accused to become a witness against himself, right? So in this way, it protects the rights of the accused person, correct? So therefore, Article 20 Clause 3 talks about self-incrimination, and we'll discuss it in the coming slides. And it implies the use of force, right? That means there is a use of force or coercion. There is a use of force or coercion while collecting the biological information, right? And when you are using the force or coercion in the collection of the samples, then it definitely violates the rights given to the accused person, correct? So therefore, it violates Article 20 Clause 3, and the collection of biological information may also lead to narco analysis and brain mapping, right? Narco analysis and brain mapping, which are being banned by the Supreme Court except in some extraordinary circumstances, right? So that means if you are collecting, if you are doing the narco analysis test or brain mapping, then it violates Article 20 Clause 3 except in some extraordinary circumstances. So in this way, the Criminal Procedure Identification Bill, which is being tabled in the Lok Sabha, the opposition believes violates Article 20 Clause 3. I hope it is clear. Guys, it also violates the right to privacy, which is being interpreted as a fundamental right under Article 21, which is right to life and personal liberty under Justice Puttaswamy case, right? So right to privacy is also being violated. Why? Because when somebody is collecting some physical or the biological samples, right, or doing a brain mapping, then it violates your fundamental right to privacy, correct? At the same time, it also violates many human rights provisions under the United Nations Charter. Guys, there is also, when you are using the force, it in this sense violates the rights of the prisoners, right? Because the Supreme Court in many cases have determined the rights of the prisoners, and there are catena of Supreme Court judgments like A.K. Gopalan 1950, similarly Khadak Singh case 1964, Charles Shobraj case of 1978, Sheila Barse case of 1983, and Pramod Kumar Saxena case of 2008. So in all these cases, the Supreme Court has come up with the right of the prisoners, and in this sense, when you use the force or coercion in the collection of the samples, it actually violates the rights of the prisoners as determined by the Supreme Court in these cases. So they may ask you that these cases deal with what, right? At the same time, it also violates right to be forgotten, right? So guys, right to be forgotten is also a fundamental right under Article 21, which is right to life and liberty, and it is also being interpreted under Puttaswamy judgment, right? That means you have the right to be forgotten, right? And when you collect the samples, you actually are violating the right to be forgotten. Guys, it is also believed that it is beyond legislative competence. That means the legislature or the parliament do not have this right to actually affect the fundamental rights, because this bill would be affecting the fundamental rights, and in this sense the legislature is not empowered to actually affect the fundamental rights unless by amendment. I hope you are getting my point. Guys, let us talk about Article 20 Clause 3. Now, Article 20 Clause 3 says that no person shall be obliged to be witness against himself. That means you don't create such situations, for the accused in the sense that he is being forced to become a witness against himself, right? And in this way, you are violating the right of the prisoner. You are violating his fundamental right. So, self-incrimination means that no person accused of an offense shall be compelled to be a witness against himself, right? That is immunity to an accused against self-incrimination, right? So this is called a self-incrimination. When you are actually compelling a witness accused to become a witness against himself, this is called a self-incrimination, right? So in this sense, this right, Article 20 Clause 3 gives immunity to an accused against self-incrimination. Guys, there have been many Supreme Court cases which actually elaborated 20 Clause 3. The first is Nandini Satpathy versus P.L. Dhani. So in Nandini Satpathy versus P.L. Dhani, the court held that the objective of Article 20 Clause 3 is to protect the accused from unnecessary police harassment, right? So guys, you all would be knowing that there have been cases of 360 degree or they say third degree treatment, right? Where the police do use the third degree treatment to compel the accused to become a witness against himself, right? So there has been cases of unnecessary police harassment, right? So the objective of 20 Clause 3 is to protect the accused from this unnecessary police harassment, and this was being held by the Supreme Court in Nandini Satpathy versus P.L. Dhani. And the right against self-incrimination is available to the witness and the accused in the same manner, right? So in this sense, it is available to both the witness and the accused, and it is applicable at every stage where information is furnished, right? Guys, the privilege under 20 Clause 3 is applied at the stage of police investigation when the information is extracted, right? So it is applied at the stage of police investigation, right? Guys, in the case MP Sharma versus Satish Chandra, it was being held by the court that a person whose name is mentioned in the FIR as an accused can claim protection under 20 Clause 3, right? That means if your name is being mentioned under FIR or First Information Report, then definitely you can you can claim the protection under 20 clause 3. In Balasaheb versus State of Maharashtra, it was held that a witness in a police case who is also an accused in the complaint case for the same incident cannot claim absolute immunity from testifying in the case. However, he may refuse to answer these questions which tend to incriminate him, right? That means the Supreme Court in Balasaheb versus State of Maharashtra said that the accused person may refuse to answer those questions which may incriminate him or which may lead to self-incrimination. That means he becoming the witness against himself, right? So therefore, guys, 20 clause 3 protects the accused person, right, or the detained person. It actually protects from the unnecessary police harassment. I hope it is clear. Now let us discuss about narco analysis vis-a-vis self-incrimination. Guys, the admissibility of the scientific techniques like narco analysis, brain mapping, etc. for improving the investigation has been a matter of debate, right? So we'll discuss that how the Supreme Court decided with regard to the narco analysis. Now in Govind Singh versus State of Madhya Pradesh, the court held that the mental state of an individual comes under the ambit of right to privacy. That means you cannot interfere in the mental health of the person, right? Because brain mapping, narco analysis, they actually interfere into the mental health of the person, right? And it comes under the right to privacy, right? The later developments in these areas observed that the authority of the state to compel an individual, right? You are compelling an individual to expose that parts of his life which he wishes to keep himself, right, is ultra vires of the constitution. That means if any police authority or any other authority compels you to expose the parts of the life which you wish to keep to yourself, right? That means if you don't want any person to interfere your mind, right, or to read your mind by many methods like narco analysis or brain mapping, then actually it is wrong and it cannot be done. It is ultra vires to the constitution, as it is in the contravention to the rights guaranteed under 20 clause 3 and 21, right? So in this sense, in Govind Singh versus State of Madhya Pradesh, narco analysis test and the brain mapping test were being rejected, and as they say that they are against right to privacy and 20 clause 3. Guys, this issue was later brought to Supreme Court in Selvi versus State of Karnataka, where the apex court rejected the High Court's reliance, because this was the High Court's judgment, right? Govind Singh versus State of Madhya Pradesh was a High Court judgment which actually banned the use of narco analysis and the brain mapping tests, to collect as a method of measurement, right? Whereas when this case went to the Supreme Court under Selvi versus State of Karnataka, the Supreme Court rejected High Court's reliance on the utility, reliability and validity of narco analysis test, right, and other such tests as method of criminal investigation, right. The court also found that it is a requisite compulsion to force an individual to undergo narco analysis test, polygraph test and brain mapping, right. So in this sense, it was being believed that the answers given during these tests are not consciously and voluntarily given, right? Because the lie detector test, the narco analysis test, the polygraph test or the brain mapping may not give you accurate results, right? Because the stage of the brain, right, it is very difficult to study the brain, right? And these tests may not give you the right answers, right? And therefore any judgment derived from these tests may not be correct, may not be 100% correct, right? So therefore The court held that the answers given during these tests are not consciously and voluntarily given, so the individual is unable to decide whether or not to answer a question. Hence, it amounts to testimonial compulsion and attracts protection under 20 clause 3, right? So that means the polygraph test, the brain mapping test and the Narco Analysis test were actually under the testimonial compulsion and they cannot be used, and it attracts protection under Article 20 clause 3, right? So the court stated that the Narco Analysis test is a cruel and inhumane treatment which violated the right to privacy of an individual, right? So therefore they identified that Narco Analysis test is cruel and inhumane, right? And it violated the right of privacy of an individual, right? So therefore the court did not permit the use of Narco Analysis test and the brain mapping except in cases where it is necessary under public interest, right? So except in the extraordinary circumstances where such tests are very important in public interest, they can be used, otherwise they are not being used, and the individual is being protected under Article 20 clause 3, you know, when such tests are being used. I hope it is clear. Let us discuss about DNA test and 20 clause 3. Guys, the courts are reluctant in accepting the evidence based on DNA test, right? Because it challenges the right to privacy and right against self-incrimination. So the court again believed that the DNA tests actually challenges the right to privacy and the right against self-incrimination of an individual, right? However, in some cases, the Supreme Court held that the right to life and personal liberty is not absolute, right? Guys, the court has decided that the DNA test also infringes the right to privacy and the right against self-incrimination, right? And therefore, however, in some other cases, the court has said that the right to life and personal liberty is not absolute. It's not absolute and can be subject to certain restrictions. Let us understand various cases. In Khadak Singh versus State of Uttar Pradesh, the apex court held that right to privacy is not guaranteed under the constitution. Now this was a very old case. The courts have allowed the DNA test on certain occasions, right? So because in Khadak Singh versus State of Uttar Pradesh, it was being held that right to privacy is not a fundamental right, is not guaranteed under the constitution, because at that time it was not a fundamental right as it is today post 2017, and the court allowed the DNA test on certain occasions to be used in investigation for producing evidence, right? Guys, in another case, Kanchan Bedi versus Gurpreet Singh Bedi, this was a case where a question arose on the parentage of a child or of a infant, right? The mother filed an application for conducting a DNA test, to which the father opposed, arguing that it would violate the fundamental rights. But the court held that where the parentage of a child is in question, directing a person to undergo a DNA test does not amount to violation of fundamental rights, right? Therefore, if you have to identify the parentage, that means who is the parent of that child, in these cases the DNA test can be done. It does not violate Article 20 clause 3 or any other fundamental right, right? So in this sense, in extraordinary circumstances or in the cases which are being decided by the court, such polygraph tests can be used, right? Or the biological test can be used. The court relied on the judgment given in Geeta Saha versus NCT of Delhi, where the division bench ordered a DNA test to be conducted on the fetus of the rape victim, right? So in Geeta Saha versus NCT Delhi, it was being decided that the DNA test can be done on the fetus of the rape victim in order to identify the criminal, right? So except in the ordinary circumstances as given in Geeta Saha case or Kanchan Bedi case, you cannot use DNA test or the other biological test, right? I hope it is clear. Guys, in conclusion, Article 20 clause 3 provides protection against self-incrimination and it gives the accused the right to remain silent, right? It gives the accused the right to remain silent. You have every right to remain silent. You are not being bound to answer each and every question asked by the police authorities, right? Why? Because if any question, which leads you to become a witness against yourself is not allowed and you are not supposed to answer that. It is, you are being protected under Article 20 clause 3, right? Now in the previous act of 1920, fingerprints and the thumb impression and the footprints were allowed, but the Criminal Procedure Amendment Bill 2022 is expanding that scope, and it would also include many other things as we have discussed, like the biological samples, iris, retina scanning, etc., right? But you have every right to remain silent, and therefore the opposition members are saying that this bill would violate Article 20 clause 3 because there is a provision of the use of force, right? At the same time, if any statement is made on some finding, then it will not be protected under 20 clause 3. An accused cannot be tortured or forced to make a confession, and no duress can be exercised on him to obtain information out of him, right? So in this sense, guys, the scientific methods like narco analysis, brain mapping, polygraph analysis, which disrupts the right to privacy, are considered to be violative of 20 clause 3 and can only be conducted in extraordinary circumstances. However, with the advancement in medical sciences, in the reliability of these tests has increased, right? Because of the advances in the medical sciences, the reliability of these tests have increased, and I believe that, in my opinion, these tests can prove to be effective tools for furnishing evidence for the speedy disposal of the cases. Otherwise, we know that in India, the judicial system is known for long cases, tariq pe tariq, right? So when we use such scientific methods, definitely I believe that it would result into the speedy disposal of the cases, and therefore they must be used cautiously, right? So we'll wait and watch that how the bill fares in Lok Sabha and Rajya Sabha, and if at all there are any changes which are being included after the opposition has raised its voice, right? I hope you have understood the session, and I hope it was interesting and enlightening, right? So wish you all the best. God bless you. Good day. Goodbye.